Hello everyone, my name is Amit Jyoti. I'm an assistant professor at the OP Jindal Global University. In this module, we will be discussing the role of ICC, ICTY and ICTR towards the development of international human rights system. The system of maintaining and improving the consistency, simplicity and efficiency of protecting human values based on international human rights, a tremendous role is played by the International Court of Justice, which we have discussed in one of the previous modules. And the other international courts like the International Criminal Court, referred to as ICC, and international criminal tribunals like the International Criminal Tribunal for the former Yugoslavia, referred to as ICTY, the International Criminal Tribunal for Rwanda, referred to as ICTR, and other international quasi-judicial bodies. After the World War I, the idea of the establishment of a permanent international criminal court had emerged. But for various reasons, none of the tribunal that was contemplated at that time could be formed. After the Second World War, two ad hoc international military tribunals, that is, the Military Tribunal at Nuremberg and the International Military Tribunal for the Far East, was established to try individuals who committed war crimes, crimes against peace, and crimes against humanity. A prominent contribution of these two tribunals was that they shook the foundation of state sovereignty as a shield against crimes in international law. The Nuremberg Tribunal observed that crimes against international law are committed by men, not by abstract entities, and only by punishing individuals who commit such crimes can the provisions of international law be enforced. Let us now look at the International Law Commission. International Law Commission, established by the United Nations Organization, made efforts to codify the legal principles that emerged during the Nuremberg and Tokyo trials. But progress on this initiative was blocked during the Cold War years. With the end of the Cold War towards the later part of the 20th century, the ICTY and the ICTR were established with limited criminal jurisdiction to try cases of violations of human rights norms. However, owing to their ad hoc nature, the quest for a permanent international court continued. This ultimately led to the adoption of the Rome Statute of the International Criminal Court in July 1998. Thus, presently, ICJ is not the only international forum to address the concerns of international human rights violations, but there are plurality of international criminal tribunals, quasi-judicial bodies, hybrid courts and treaty monitoring bodies that equally contribute towards the development and protection of human rights law. A primary distinguishing feature of the alternatives to ICJ is that in these forums, either individuals can bring claims before them or because they have jurisdiction to prosecute individuals for violations of human rights norms. It has been expressly acknowledged in Article 33 of the UN Charter that the peaceful settlement of disputes can be and should be sought through different ways, which fall broadly into three categories: political, quasi-judicial and judicial. Additionally, Article 95 of the Charter states in rather unambiguous language that nothing in the present Charter shall prevent members of the United Nations from entrusting the solution of their differences to other tribunals by virtue of agreements already in existence or which may be concluded in the future. Our discussion in this module shall focus on the role of ICC, ICTY and ICTR in the development of international human rights law. Now let us first discuss the International Criminal Court, referred to as ICC. In the 1990s, after the end of the Cold War, the tribunals like the International Criminal Tribunal for the former Yugoslavia and for Rwanda were established as a result of consensus that impunity is unacceptable. However, because these were ad hoc tribunals, that is temporary, they were established to try crimes committed only within a specific time frame and during a specific conflict. There was general agreement that an independent permanent criminal court was needed. The purpose was to have a judicial body that could prosecute serious crimes against humanity, no matter who committed them, and this body should be able to try the perpetrators of gross violations of humanitarian law, such as those committed during international or internal military conflicts. The International Criminal Court is governed by the Rome Statute of the International Criminal Court of the year 1998. The Rome Statute was adopted by 120 states on July 17, 1998. This adoption led to the legal basis for establishing the Permanent International Criminal Court. However, the statute entered into force on July 1, 2002 when it was ratified by 60 countries. It only started its work in 2003. At present, the Rome Statute has been joined by 123 countries. It is the Rome Statute that governs the jurisdiction and functioning of the ICC. The ICC is the first permanent treaty-based international criminal court established to help end impunity for the perpetrators of the most serious crimes of concern to the international community, like genocide, crimes against humanity, and war crimes. Its seat is at The Hague in the Netherlands. It is an independent international organization and is not part of the United Nations organizations like the ICTY and ICTR that we shall discuss in some time. And therefore, the UN members are not ipso facto members of the ICC. The primary source of the ICC funds is the state parties, but it also receives voluntary contributions from governments, international organizations, individuals, corporations, and other entities. The court is composed of 4 organs, that is, the Presidency, the Judicial Divisions, the Office of the Prosecutor, and the Registry. The Presidency consists of 3 judges and it is responsible for the overall administration of the court except the Office of the Prosecutor. The Judicial Division consists of 18 judges who are responsible for conducting the court proceedings at various stages. On the basis of the stages, it is organized into the pre-trial division, the trial division, and the appeals division. Judges are subject to staggered election systems with elections that are held every 3 years and they generally cannot be re-elected. The office of the prosecutor is responsible for receiving referrals and any substantiated information on crimes within the jurisdiction of the court for the purpose of examining them and further conducting investigations and prosecutions before the court. The last organ, which is the registry, is responsible for the non-judicial aspects of the administration and servicing of the court. The ICC is a court of last resort. It will not act if a case is investigated or prosecuted by a national judicial system unless the national proceedings are not genuine. For example, if the proceedings were taken solely to shield a person from criminal responsibility. Therefore, its jurisdiction is complementary to that of the national courts. In addition, the ICC only tries those accused of the gravest crimes. ICC can be approached by the victims of crimes and their families to express their views and concerns and to claim reparation for the wrongs suffered. In conduct of its proceedings, ICC follows the highest standards of fairness and due process. Article 12 of the Rome Statute provides that the jurisdiction of this court extends to the parties to the statute, but a non-party can accept the jurisdiction by lodging a declaration to this effect. According to Article 13, the court may exercise jurisdiction with respect to crimes falling in its jurisdiction in three ways. 1. When the matter is referred to the prosecutor by a state party to the statute under Article 14. Second, when the matter is referred to the prosecutor by the Security Council acting under Chapter 7 of the UN Charter. And thirdly, when the prosecutor himself initiates investigation in respect of such crimes. According to Article 5 of the Rome Statute, the overall jurisdiction of the court is limited to the most serious crimes. It has jurisdiction with respect to the four types of crimes, which are 1. The crime of genocide, 2. The crimes against humanity, 3. The war crimes, and lastly, the crimes of aggression. According to Article 22 of the Rome Statute, the principle of nullum crimen sine lege is applicable, which serves to safeguard a state's sovereignty because the court only has jurisdiction over crimes insofar as they have been included in the statute by the negotiating states. Under Article 22, 23 and 24 of the Rome Statute, it provides for various rights of the accused aiming at ensuring a fair trial and the non-retroactivity of the temporal jurisdiction of the court. According to Article 21 of the Rome Statute, a hierarchy of the laws which shall apply in matters before the ICC has been provided. At the top of the hierarchy are the statute, elements of crimes and its rules of procedure and evidence. Number 2, where appropriate, applicable treaties and the principles and rules of international law, including the established principles of the international law of armed conflict. Number 3, general principles of law derived by the court from national laws of the legal systems of the world, including, as appropriate, the national laws of the states that would normally exercise jurisdiction over the crime, provided that those principles are not inconsistent with its statute and with international law, and are internationally recognized norms and standards. The court may apply the principles and rules of law as interpreted in its decisions previously. It has been stated in Article 21 of the statute that the application and interpretation of the applicable laws has to be consistent with internationally recognized human rights and there shouldn't be any diverse distinction on the grounds of gender, race, age, color, language, religion or belief, which can be political or other opinion, national, ethnic or social origin, wealth, birth or other status. Until now, in 22 cases in 9 situations have been brought before the ICC. As of now, 4 state parties to the Rome Statute of Uganda, the Democratic Republic of Congo, the Central African Republic and Mali have referred situations occurring in their territories to the court. In addition, the Security Council has referred the situation in Darfur, Sudan and the situation in Libya and both non-state parties. After a thorough analysis of the available information, the prosecutor has opened and is conducting investigations in all of the above mentioned situations. A direct relationship has been established between the ICC and the ICJ under Article 119(2) of the ICC statute, which states, any other dispute between 2 or more state parties relating to the interpretation or application of this statute which is not settled through negotiations within 3 months of their commencement shall be referred to the Assembly of State Parties. The Assembly may itself seek to settle the dispute or may make recommendations on further means of settlement of the dispute, including referral to the International Court of Justice in conformity with the statute of that specific court. If the states fail to enforce their judgments, they can rely on the potential measures that can be taken by the Security Council acting under Chapter 7 of the Charter for supporting their judicial activity and the enforcement of their judgments. Now, let us look at the International Criminal Tribunal for the former Yugoslavia. The Security Council decided to establish ICTY due to circumstances of grave injustice in the former Yugoslavia since 1991. There were ravaging effects in the former Yugoslavia, Slovenia and Croatia and then to Bosnia, where some instances of ethnic cleansing, which included deportations, mass executions, mass sexual assaults and rapes and concentration camps were being reported. At this point, the Security Council asked the United Nations Secretary General to establish a commission of experts to report on evidence of grave breaches of international humanitarian law in the former Yugoslavia. By its resolution number 808, the Security Council on 22nd February 1993 decided that an international criminal tribunal should be established and asked the United Nations Secretary General to prepare a report. The Secretary General, Ghali, reported within 60 days with the statute for the formation of the ICTY. The International Criminal Tribunal for former Yugoslavia, which is referred to as ICTY, was established on 25th May 1993 by the resolution number 827 of the Security Council. This resolution had to be passed by the Security Council as there were numerous complaints of serious violations of international humanitarian law committed in the territory of the former Yugoslavia since 1991. The ICT was the first war crimes court created by the UN and the first international war crimes tribunal since the Nuremberg and the Tokyo tribunals. It was established by the Security Council in accordance with Chapter 7 of the UN Charter. According to Article 2, 3, 4 and 5 of the Charter, on the subject matter jurisdiction and Article 9 Clause 1 on the jurisdiction ration temporis, the ICTY has jurisdiction over grave breaches of the Genocide Conventions of 1949, violations of the law or customs of war, genocide and crimes against humanity committed in the territory of the former Yugoslavia since 1st January 1991. The ICTY has a special detention unit located at The Hague. The mission of the ICTY is fourfold. First, to bring to justice persons allegedly responsible for serious violations of international humanitarian law. Second, to render justice to the victims. Third, to deter further crimes. And fourth, to contribute to the restoration of peace by promoting reconciliation in the former Yugoslavia. The case of the ICTY is quite vast and covers many issues of international humanitarian rights and humanitarian law. Until now, the ICTY has charged over 160 persons, including heads of the state, prime ministers, army chiefs of staff, interior ministers, and many other high and mid-level political, military, and police leaders from various parties to the Yugoslavia conflicts. Let us now move to our discussion on the International Criminal Tribunal for Rwanda. In April 1994, a massive ethnic conflict broke out in the Central Africa, resulting first in the genocidal murder of about 500,000 members of the Tutsi tribe by members of the Hutu tribe in Rwanda, and then the displacement of hundreds of thousands of Hutus into the territory of neighboring countries. After 18 months of the establishment of the ICTY, upon receiving request of the government on the territory of which the crimes were taking place, the International Criminal Tribunal for Rwanda, is referred to as ICTR, was established on 8 November 1994 by resolution number 955 of the Security Council due to serious violations of humanitarian law that were being committed in Rwanda. To promote international peace and security in Rwanda, the Security Council established ICTR to prosecute persons responsible for genocide and other serious violations of international humanitarian law committed in the territory of Rwanda between 1st January 1994 to 31st December 1994. This is one primary difference between the ICTY and ICTR, where the former has a start but no end date. The ICTR is located in Arusha, Tanzania. Both ICTY and ICTR share the appeal chamber which is based in The Hague. Comparatively, ICTR is said to have made a greater contribution towards securing international peace and justice as it has obtained custody of several high-level government and military officials who are suspected of planning and inciting Rwandan genocide. Since it opened in 1995, ICTR has indicted 93 individuals responsible for serious violations of international humanitarian law in Rwanda in 1994. The ICTR is the first ever international tribunal to deliver verdicts in relation to genocide and the first to interpret the definition of genocide given in the 1948 Geneva Conventions, and the first ever tribunal to hold members of the media responsible for broadcasts that were intended to inflame the public to commit acts of genocide. The ICTR delivered its last trial judgment on 20th December 2012. Now the work is only pending before the appeals chamber. The ICTR will formally close with the return of the appeals chamber's judgment in its last appeal. Now let us compare ICC with ICTY and ICTR. ICTY and ICTR are called ad hoc tribunals. They have a closer relationship with the Security Council as compared to the ICC. They have wide range of powers owing to the fact that they were established by the Security Council acting under its obligation of Chapter 7 of the UN Charter. According to Article 29 of the UN Charter, ICTY and ICTR are subsidiary organs of the Security Council. As such, they are dependent on the United Nations in administrative and financial matters, although as judicial institutions, they are independent of any one state or group of states, including their parent body, that is the Security Council. The ICTY and its sister tribunal, the ICTR, have been endowed with primary jurisdiction in contrast to the jurisdiction of ICC. Under Article 29 of the ICTY statute, UN members have a legal obligation to render cooperation and judicial assistance to ICTY as determined by the Security Council under Article 48 and 49 of the Chapter 7 of the Charter. Now let us look at some hybrid courts as well. The beginning of the 21st century witnessed the birth of the third generation of international criminal bodies, which are famously referred to as the hybrid criminal bodies. Currently, the four bodies referred to as the hybrid courts are: 1. Crimes Panel of the District of Delhi of East Timor. 2nd, Regulation 64, Panels in the Courts of Kosovo. 3rd, Court of Sierra Leone. And last, the Extraordinary Chambers in the Courts of Cambodia. Each of these courts is composed of independent judges working on the basis of predetermined rules of procedure and rendering binding decisions. To fulfill their objectives, they need to rely on international cooperation and judicial assistance by states and international organizations. Despite having commonality of objectives, when compared to the tribunals that we have just discussed, these hybrid courts are different to the extent that they are part of the judiciary of a given country, while in others, they have been grafted onto the local judicial system. But in all cases, their nature is mixed, incorporating at the same time international and national features, which is why they are referred to as the hybrid courts. With this, we conclude our discussion on ICC, ICTY and ICTR, and also our brief discussion on the hybrid courts. Thank you for listening to this module.